To be informed. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Today, we're joined by Paul Cott of Law and Lydiard, who will be taking us through business disputes and how to escalate a business dispute in Victoria. Oftentimes, you might have an issue with a business and want to dispute a particular interaction you've had with them. What do you do next if you need to escalate that dispute that you have with the business? Today's seminar was to be presented last week, but due to unforeseen circumstances, we've had to postpone and record it today. I would like to acknowledge the traditional owners of the lands on which we are meeting today and pay my respects to their elders past and present. Today's session is about business disputes, and the jurisdiction that this matter relates to is the Victorian jurisdiction. So if you are joining us online today, please do bear in mind that other states and territories in Australia have different escalation pathways. And any information shared in this seminar is general information only, and if you do require any specific advice, please do contact a professional in the relevant space. Paul has kindly also prepared a one-page handout, which we will share following today's session. And there'll also be a chance for Q&A. As this session is being recorded post the live event, any questions that we've received ahead of time will be answered through this session. So without any further delay, Paul, I'll hand over to you.
Yep, thanks, Carl. You can just bring up the first slide. So it's how to escalate a business dispute. We're going to talk about the next steps, which we recommend people take if you have been provided with a product or service and you're not happy with the product or service. There's some issue with it, such as it's defective, it's caused you some financial loss, it doesn't do what it's supposed to do, it doesn't have the specifications that you and all those services, all those concepts relate to services as well. You haven't been provided basically with what you are contractually entitled to receive and have paid money for that service, and you're not happy, and you may seek some compensation or a refund. And various other remedies such as a reversal of the contract, amendment of the contract, and various other remedies like that, which a court or tribunal may be able to award, which we'll get to. So once those issues have arisen with a product or service, you should send a letter of demand. I'm probably jumping ahead here, but you don't necessarily need to get a lawyer to write a letter of demand, but one that's written by a lawyer is more carries more authority and maybe more legalistic and sets that in more detail. But I've seen plenty of clients without a lawyer write their own letter of demand and have served the purposes that is required to have. So the letter of demand does need to clearly set out what you are seeking and give it a time frame and why. So the time frame is important because you need to tell the other party when they need to do something by, otherwise they'll just regard it as open-ended and they'll respond whenever they wish. So responses of letter of demands in my varied widely, as we say. Sometimes there's no response at all. That's not that common. You'll often get a letter in response back, either from the other party or from the other party's lawyer. An agreement to the demand in its entirety is fairly rare, but it does happen sometimes, and that's why it's worthwhile spending some time into writing a letter of demand, because the better the letter is written, the more you may get agreement to the claims in the demand entirely. You might get a partial agreement to the demands and partial disagreement, or you might just get a letter in response from a other party or a lawyer completely denying all the claims and not providing or not agreeing to provide anything by way of what he some other subsidiary bodies that go to which should. So the question is, can someone ever go to court instead of issuing a letter of demand first? Generally, courts highly encourage people to try to resolve matters themselves before they issue a proceeding. In fact, a court might even say, where no letter of demand has been issued, well, yes, you've won the case, so to speak, but we are not going to give you all your costs because you didn't even try to resolve the matter prior by a formal letter, sending claims. And so it might be that there is some cost penalty, so to speak, against you as a successful party in a court or a tribunal, where normally you'd get your costs back if you get a lawyer, but they might, in this case, where no letter of demand was sent prior, reduce the costs that are going to be awarded. The demands that can be made in a letter of demand are seemingly endless, as we say, but normally it's compensation. Sometimes it's a refund of the full purchase price if the product is at defective in a legal category. Or law, the Australian Competition and Consumer Act. If it's a major defect, you might have a right to a full refund. The compensation, an apology is rarely sought and rarely given. Sometimes you want a replacement product. Sometimes you want the other party to fix the product. A lot of the time, though, you don't want the party to fix the product because you've been provided with their product or service and you're not happy with it, so you've lost faith that they will give you a proper product or service next time around. So normally it is, give me my compensation for my losses that have incurred, excuse me, due to the other party's breach. Thanks, Carl. I'll just go on to the next slide, which is options following a letter of demand. So your options obviously depend on what the response is. If it's an agreement to all the demands, well, that's well and good, and you'll make arrangements for those things to happen. Options following a letter of demand, is a lawyer required? Generally, yes. That is, if the claims made in the letter of demand are not provided, then generally, yes, a lawyer would be able to assist with legal and hopefully some non-legal demands as well. Lawyers can help. However, and I say this with a little bit of reluctance, but it is the case that some lawyers, or some people say that some lawyers, excuse me, result in the dispute being escalated, as particularly if the other party has a lawyer as well, because then you can then get into a series of correspondences back and forth between the lawyers, which can help sometimes to resolve certain issues or narrow the issues in dispute. But can then also sometimes escalate the dispute and make it a more emotional and costly and time-consuming exercise. A very common question, like, can you legally claim legal costs or other costs? Usually we are talking in this context about legal costs. Obviously, if a client sends a letter of demand without a lawyer, you can't claim costs because presumably there are no costs that have been incurred. And that is, when I say cost, that is separate and apart from the loss or damage on the compensation that you seek. Surprisingly, even in this day and age, even and then you will get a lawyer, send a letter of demand and claim legal costs, which it is in Victoria at least. In fact, sorry, it is in Australia-wide. It is unethical for a lawyer to claim legal costs in a letter of demand, the legal cost being the cost of writing that letter, unless legal proceedings have actually been issued. As I say, unfortunately, does not mean that does not happen. although it is pretty rare. And as we said, if the party sends a letter themselves, and there are no legal costs to claim yet. We can go on to the next slide. Thanks, Carl. Or I'll just continue. Non-court options. So in Victoria, we've got the Victorian Civil and Administrative Tribunal, which replaced, I think it might have even been around 20 tribunals, small tribunals, which were tribunals assisting people to resolve matters in certain specified areas, such as the Tenancy Tribunal, Small Claims Tribunal, Residential Tenancy Tribunal. I think there was even a Domestic Building Tribunal. They've all been amalgamated into VCAT with a long series of lists. I do encourage people to go onto the VCAT's website and have a look at, I think the tab up the top is what areas we can help resolve. And even I was surprised last time I checked on there, the very wide range of issues that VCAT can deal with, such as even complaints against lawyers, co-ownership disputes, guardianship and administration, domestic building, civil claims list, which deals with a lot of the issues that we're talking about today, and that is supply and provision of goods and services. There's a range of other lists too, but you might be surprised how many there are there. Professional regulation list is another one, dealing with disputes between professionals and their regulators. Consumer affairs is a cost-free, I guess you'd call it a dispute resolution service, but they generally give advice more than actually do casework per se. The outcomes that can be achieved are potentially broad-ranging and really depend on what the parties agree to do. So apologies are sometimes sought, but actually rarely given in practice. CAV, or Consumer Affairs Victoria, does have a website. There's a lot of information there. They do receive and act on complaints sometimes. They do actually make what's called a determination. Parties can't be compelled to engage with the process in consumer affairs. They also can't be compelled to comply with a determination of consumer affairs. It is all really voluntary. However, it leaves disputes outside the court and tribunal system. Lawyers are not involved. It's relatively quicker, definitely free, and a lot more informal and not legalistic. So, but as I said, there is a disadvantage that they can't compel or enforce an outcome. They can't even compel someone to do a mediation. So the other party says, I'm not going to mediate. There's nothing that Consumer Affairs can do. Then we have the ACCC, about the Australian Competition and Consumer Commission. Is the body that many people turn to in this area. Now, again, they've got a very good website. Advice can be sought. However, unless there are large-scale consumer issues where there is a pattern of behaviour from a particular business, such as clothing being flammable or unsafe, children's toys which are unsafe, and or public recalls such as defective vehicles that are unsafe, they generally don't act on behalf of individual consumers. I'm going to read out from their website a very short snapshot of what the ACCC does and does not do. We accept and record reports of information about business practices and behaviours that concern you. We respond to reports when we have information that may help you, or you have asked a question about your rights and obligations under the law. So a bit general, but it is a body that you can sometimes get some advice through. What they don't do is, and this is a critical thing, we don't resolve individual or provide legal advice on rights and obligations under the law. So that's a limitation. We don't comment on investigations or what action we may take from the information provided in reports we receive. However, they do provide a free advice service, and they are basically a monitoring and an education body more than an enforcement body. So then we go on to court options. Whenever you issue a proceeding, and I know this sounds very basic, but it's one that I come across, is where somebody might have already issued a proceeding and they come to us for assistance, is, well, I say to them, one of the first questions I say is, what were you actually trying to achieve? What's your outcome? Or what is your number one possible or hoped for takeaway out of this court proceeding? And some people don't even know. They haven't thought about it. They just issue a proceeding. It's good to know what outcome you hope to achieve, and often that is compensation, but there might be other things. There might be you want a refund, partial refund, full refund. You want the item fixed. You want a replacement. You want parts being supplied. There's various other things that can be achieved in a court action. So as we say here, you may win on all the issues, or you may win in part. It's probably relatively rare that everybody wins on every issue they claim. However, that might not matter to the overall outcome. You may still get the overall outcome that you seek, even if you win only on some issues but not others. Or, of course, unfortunately, if you may lose the case entirely, which means that if the claim is made in court, you may need to pay the other side's legal costs, if any legal costs have been incurred. And if you win the case, of course, you may, that is, particularly if lawyers are involved, you may get your legal costs paid back, but it will never be a full indemnity. It'll usually only be what's called party basis costs, around 66% or thereabouts of your costs will either be paid as a loser or paid to you as a winner. And significantly, and this is something that people really need to consider, it's all right, all well and good to go off to court, have the money to do so, know which seeking comes legally permissible under law, but court matters, they really do involve costs and time and stress. And I can't overemphasize the importance of the time and the stress involved in matters. I've seen marriage breakups happen over the years where a married couple get in business disputes and they go on for that long. It causes stress in the relationship and the relationship breaks down. As to legal costs, then in VCAT, they know the other party's cost, but if you win, then you don't get paid your costs back, which is different to court. But there are exceptions, particularly in the building and property list in VCAT, because those matters are often quite more complex. Then the tribunal often exercises its discretion to award costs to the winner against the loser in VCAT. Timeframes as well as cost, time and stress, which we just talked about. So timeframes can be very lengthy in VCAT or in court. It's not unknown that a court matter of a relatively complex or even a relatively simple commercial dispute, say in the county court, may take 1 to 3 to 4 years, even in some cases, to reach its conclusion if there is a mediation and then a hearing. In VCAT, there has been some issues, some long delay. Some members that they were short on. However, I'm led to believe recruited and those members are in the tribunal and some of that backlog is being cleared. In court actions, as we said, generally parties are seeking compensation. The magistrates court, though, does not have the legal power to award more than $100,000. You may choose to forego the excess for the reason of keeping the matter in the lower court so that potentially the matter goes more quicker and slightly less formal. So you may wish to forgo, say, the claims of $100,000 plus $300, $100,300. You may wish to forgo the excess and still keep it in the magistrate's court. As I've said here, it is rare for consumer matters and business-related disputes, particularly between a business and a consumer, as opposed to a business and a business, to go to the Supreme Court. It's probably relatively rare that they would go to the county court, although there is provision for it. And if you do go to the county court when you could have issued in the magistrates court, the county court being the middle court in the court hierarchy, there can be penalties against you if you issue in a court higher in the hierarchy than what you should have. The court may well still hear the case because they've got jurisdiction, but they might give you a cost penalty so that if you win, you don't get all your costs. And if you lose, you may not have to pay as much costs because you have issued in the incorrect court. About early dispute resolution, what us lawyers used to call alternative dispute resolution, but given that it's so common now for parties to resolve matters by these methods rather than court, we're now calling it early dispute resolution, so early in the process. So the first one there is negotiation, which we're always negotiating. We're always negotiating disputes, we're always negotiating in everyday life, but it can be done through communications, through emails, phone calls, formal or informal letters, informal roundtable conferences, with or without a mediator. There can be what's called offers of compromise, quarter bank written offers made by lawyers where it gives some incentive in terms of costs that can be awarded if the matter was to proceed further in terms of costs. So it gives an incentive for the party to seriously consider the offer that's been made. Otherwise, there may be penalties down the track. Mediation is basically a negotiation where the parties sit around a table. They have an independent third-party facilitator called a mediator, who that mediator does not necessarily have to have any expertise in the area. So, for example, a person who is not versed in family law can still mediate family law disputes. Mediation is very, very effective to resolve matters. I don't know what the percentages are, but I do know that in my area of specialty in employment law, something like 80 to 90% of matters are settled at mediation, which is a good segue into the next one, conciliation, because in the Fair Work Commission, in the employment law sphere, they actually called conciliation, which, as we say there, is really mediation but in another name. But the independent third-party facilitator will have some expertise or knowledge in the area. So again, by way of example, employment law, Fair Work Commission, a lot of the mediators have previously worked as a law firm or in a law firm, as an employment lawyer. They may have worked for a trade union. They may have worked for an industrial association. They may have worked previously as a workplace investigator, but they've got some knowledge of the subject matter area, which can resolve disputes because they can give, although they would never say that they give legal advice, because the lawyers for the parties that are present would be giving the legal advice, but they can give, in a rough sense, some advice to the parties as to certain sections of the Act and just utilising their own knowledge, skills and experience. So conciliation is a very effective method of early dispute resolution methods, because the independent third-party facilitator does know the area at hand and can be a little bit more hands-on with resolving or attempting or helping the parties to resolve a dispute. And then the last one we have is arbitration, which I guess it is classed as early dispute resolution only because generally you can do arbitration outside the court sphere. You don't need to have issued legal proceedings. You may have an agreement between them to arbitrate the dispute in the event of a dispute, because arbitration is not a dispute resolution forum where the outcome of the dispute is in the parties' hands, and only the binding determination is made. Arbitration is a very effective dispute resolution method, particularly for commercial disputes. As I say, the outcome imposed on the parties, it can be run in a semi-formal court-like setting, That is where the parties make submissions for documents, and there is a binding decision made in writing with reasons by an independent arbitrator who does not necessarily have to be a judge or a magistrate. Thanks, Carl.
Thanks, Paul. So just to summarize, Paul's details on screen. If you do have any queries, please do reach out to him. Paul's also prepared a one-page handout, right? So following the session, this will be emailed out to registered participants. And the session is also recorded too, so you'll probably be watching this online, given we are recording this after the live session was scheduled to take place. And this is also as a reminder, today's session is current. The information presented in today's session is current as of this month. So if you do rely on it in the future, please do check its currency. We'll go to Q&A, Paul, as this session is being recorded post live session. We don't have too many questions, and I think you've covered most of it in your seminar. Just on the letter of demand point, you mentioned it's always important to sort of explain the where, the why, the when, the what. I think you sort of have to go through that level of detail to make it clear. How do you sort of, advise your clients when sending those letters of demand, if they engage you at that stage, or if they don't, just in general, how do you, what are your thoughts around the strategy around sending those letters out? Who do you send it to? Do you follow the pathway suggested by the business? Or, do you start emailing the CEO? What sort of strategies or tips or traps can you suggest around strategy when sending out those letters of demand so it gets some sort of traction and reception, I guess, in the business?
So I think there's probably two broad principles. One is you do need to generally send these letters to somebody high enough in the organisation to have some decision-making power. Otherwise, it might just be that the letter is passed on or may not be passed on to the relevant person. Or the other concept is that you often will send the letter of demand to the person or people dealt with. Overriding principles. But I think that the most important one is send it to somebody senior enough, such as the directors or such as the manager. Or chief executive officer, somebody higher up in the organisation, because if there's a systemic problem in the organisation, they may want to have a look at it, because if it's not the first complaint. And secondly, as I said, they have to have some decision-making power or authority to make a decision in respect to the claims in the letter.
Yeah. And is it bad if a business doesn't respond to a letter of demand? So if someone sends this out, there's a valid concern, a genuine complaint, the business doesn't respond, will that be looked on unfavorably by a court or by a tribunal if it were to get escalated through those channels?
Well, would be, and by analogy with where somebody issues a proceeding without, if there's no response, then it can be viewed in the same by a court or tribunal. The matter has been brought before the court or the tribunal, where it could have been resolved out of court if the respondent, so to speak, did do a response. So it's not looked on well. And even as a business decision, for the business to receive a letter like that and not even respond, well, people talk. They should always, because you need to be aware of the defamation laws. But if a business has had concerns addressed to it and has not even responded, taken the time or the effort to respond and spent the money to respond, then the consumer is well entitled to ask, well, how seriously are they treating my complaint? So it doesn't look good.
Yeah. Yeah, I think you need to sort of genuinely resolve the disputes, right, and take those steps. And if as a business you don't bother considering the issue or the complaint, then or the incident, then it's not It's not a good look, is it, from an ethical and their sort of trading
That's
perspective.
right.
Yeah.
Because it might be that there are cases where, in response to the letter of demand, the consumer or the pope who wrote the letter actually says, "Well, hang on, maybe I haven't got such a strong claim after all," and maybe not even putting it any further. So to respond can sometimes nip the problem in the bud for the business too.
Yeah. And Paul, from your experience, I know you touched on this, but just to reiterate, sort of, if you do take matters through tribunals, are they binding? And if they want to enforce those orders that are made by a tribunal, what do they need to do?
Sorry, what was the question again?
So, Paul, if they take it through VCAT, if an individual lodges a case, and I know VCAT can tend to be a non-lawyer space where individuals can make claims through to the tribunal against businesses. When VCAT makes an order, are those orders binding, and how do they get enforced?
Oh, that's a good question because, for example, an order, for example, whereby somebody used to pay a sum of money to the other party, a VCAT order is not enforceable of its own right. So it doesn't have any like actual legal status in the sense of being enforceable. I mean, I don't know what the statistics are, but I would imagine that most people, because you have to have some respect for a child. It's heard the evidence and the parties there say, it's provided them with procedural fairness, it's handed down a decision, so parties generally comply with it. But if they don't, you can register it now pretty easily with the magistrate's court, and then it's enforceable. And it also, if it's a monetary order, once a VCAT judgment is registered as an order of the court, it comes on the person's credit record. And if it's not paid, it's their fault. And that then shows that the party issuing is serious, and that they have rights to enforce the judgment or the order. And there's not even a fee to enforce those orders anymore. There used to be a fee to register a VCAT order in the court. Now there's not even a fee for it. You just send it to VCAT, say I want this to be enforced. They send it to the court, and a week or two later you'll get a court order, which packs a lot of punch. As I said, generally most people would comply with a court order. If they don't have the respect for the tribunal, then they generally have the respect for the court.
Yeah. And I think that's quite an important sort of step, isn't it, to make it more accessible for individuals who have got the order from VCAT to then, take the step to make it enforceable so that then the outcome can be, achieved in reality rather than just being a theoretical outcome on a piece of paper, right?
Yeah.
So that's
Yeah, I'll give you an example from many years ago. I was aware of a VCAT judgment VCAT order of around about $400,000 to do with a building dispute many years ago. And I was involved in the process for about 5 years, and at that end of that 5 years, that money had not been paid, not a cent of it.
Yeah, that's not unfortunate, isn't it?
And I don't recall exactly why the client didn't go to court. It may have made no difference. Maybe he didn't want to spend the money all the time to take it to court. He said that the VCAT judgment should be recognised, and it just wasn't.
And that's sort of a deficiency in the legal justice system, isn't it? That you take faith in the tribunals, processes to, as you say, provide a fair hearing and hear both sides. And out of all of that, the outcome can't be achieved through an order. Then it's more so just a fact-finding exercise, isn't it, really, and a bit of a discussion between two parties. I think it's definitely a great, I guess, improvement in that space to allow that to happen through the magistrate court.
Yeah.
Well, that sort of brings us to the end of the key questions that we'd received. Most of the other questions that were asked were answered through Paul's seminar. Just to share on screen again, there's Paul's details. So if you do have any questions about the subject matter, of course, feel free to reach out to Paul and he can advise you directly. And Paul's a friend of Be Informed, so he's presented quite a few other seminars as well, and most people have found value from that, so that's good to hear. So that brings us to the end of today's session. This session is a recording of a live session, so hopefully you found this useful. And please do follow us on social media. We rely on word of mouth to help spread the work that we do, and hopefully those that attend will watch the recording at a later stage and make more informed decisions in their activities and day-to-day life. This session is being recorded, of course, so you're most likely watching this online anyways, so that's great. And there's a one-page handout that will be shared, so you will receive that, so you can keep it on hand and share it with family and friends who need it. So that brings us to the end of today's session. Thank you all for your participation. Thank you, Paul, for your time and support.
Thank you.
And look forward to seeing you again in the future.
My pleasure.
Thank you all. Thanks, Paul. Bye for now.
Thank you.